The court concludes that while there is such a distinction, the law is that charges can be added which do not have to be specifically related to the evidence introduced at the preliminary examination. Perhaps the closest case on the facts to those in this case is that of the State v. Bailey, reported at 6-5 Wisconsin 2D 331. It's a 1974 Wisconsin Supreme Court decision. The complaint in that case charged Bailey with one crime, first-degree murder. The information filed after the preliminary examination added counts of indecent behavior with the child enticement, and attempted child enticement. The additional charges related to the abduction of the child, who was subsequently murdered by the defendant. In upholding the prosecutor's authority to add these charges, the court ruled as follows. In our view of Section 970.0310 does not prohibit the prosecutor from including in the information, once a defendant has been bound over, charges in addition to those advanced at the preliminary hearing, so long as they are not wholly unrelated to the transactions or facts considered or testified to at the preliminary. This view is consistent with the legislative statement in Section 970.031 that a preliminary hearing is held, quote, for the purpose of determining if there is probable cause to believe a felony has been committed by the defendant, end quote. Once it is determined that the defendant should be bound over for trial on at least one count, the purpose of the preliminary has been satisfied, and the prosecutor may, in his discretion, allege such other offenses as permitted by the limitations stated above. In this case, assuming there is no evidence presented as to them at the preliminary, it is clear that the sex-related offenses, counts 2, 3, and 4, were not wholly unrelated to the murder count. They are related in terms of parties involved, witnesses involved, geographic proximity, time, physical evidence, motive, and intent. There's a strong parallel between the facts recited in Bailey and those here. The child enticement counts were related to crimes that immediately preceded the murder and were part of the motive for the murder. Now, as the defense points out in its brief, the court in Bailey went on to find that the facts introduced at the preliminary examination in that case would have been sufficient to bind over on the enticement counts anyway. So the language quoted could be considered dicta, not necessary to the court's decision. And I believe that's an entirely valid distinction on the defense's part. I think the language could easily have been characterized as dicta, and, in fact, it was. It wasn't really necessary to the court's decision because the court found the facts introduced at the prelim by themselves would have been sufficient to support the additional counts. However, Bailey has been cited in a number of subsequent Supreme Court decisions, and the court has never backed away from its rationale, whether or not that rationale is characterized as dicta. In fact, the Supreme Court has accepted the dicta from Bailey as the law. For example, in this case of State v. Burke, the court held as follows. Fish and Bailey hold that, in a multiple offense transaction case, once the defendant has been bound over for trial on at least one count related to the transaction, the prosecutor may, in the information, charge additional counts not wholly unrelated. Bailey further establishes that the direct evidence related to the additional counts may not have been presented at the preliminary examination. In the court's opinion, We are not left to wonder how additional charges must relate to the evidence introduced at a preliminary examination in order to be includable in an information. The test has been repeated often. To meet the test of transactionally related or not wholly unrelated, the charges must be related in terms of parties involved, witnesses involved, geographic proximity, time, physical evidence, motive, and intent. That's the test that the court is required to apply, and that test can be applied in this case. Referring specifically to the facts in this case, the court concludes that the new charges clearly meet the test which the Supreme Court has established. The parties involved in the alleged crime are the same. That is, it's the same defendant and the same victim. The witnesses, who would be the persons alleged to be present at the time of the crime, are the same in each case. With respect to geographic proximity, everything is alleged to have happened at the same location. With respect to time, the new charges are alleged to have immediately preceded the homicide and mutilation of a corpse charge from the original complaint. In addition, the physical evidence involved is likely to significantly overlap the charges in the original complaint and the amended complaint. With respect to motive and intent, the kidnapping, false imprisonment, and sexual assault charges will form an important basis on the alleged motive for the homicide and mutilation charges. The court concludes that it's difficult to imagine how the additional charges could be more closely related to the original charges in this case than they are. Thus, the court concludes that the state is permitted to add the new charges, and the defendant is not entitled to a preliminary examination on the other charges. For those reasons, the court is denying the motion of the defense to dismiss I will reiterate the court's denial of the motion to dismiss the amended complaint. And the court also denies the motion requesting an additional preliminary examination on the additional charges. Mr. Kratz, I will direct you to prepare the order in this case. Procedurally, at this point, I don't know if the state is prepared to proceed with an information at this time or not. Mr. Kratz? Attorney Kratz. I think probably, Judge, the court should schedule an arraignment at which time the amended information can be filed. The court. I know, Mr. Strang, you indicated previously in the correspondence that the defense may seek a permissive appeal from the court's ruling if the court ruled as it did. I don't know if the defense is going to seek to delay with respect to arraignment or not. Attorney Strang. Well, that's a question. The court is right. And I agree with Mr. Fallon's assessment of Webb. I read that case the same way, in the sense that if we think the court erred on the sufficiency of the complaint or on our entitlement to a preliminary hearing, the only time we can raise that is now, because the trial will certainly cleanse the error or render it harmless, if in fact there was an error. So this is not a usual case. The stakes are very high. Obviously, we understand what they are for Mr. Avery, for the Halbach family, for the state, people of the state. I think it prudent for us to ask the Wisconsin Court of Appeals for leave to file an appeal here, permissively, that the court doesn't have to, that is, the Court of Appeals doesn't have to grant leave. But if I don't ask, I'm giving up my only opportunity to be heard on the correctness of the court's ruling and to have those rulings reviewed. So I do and will do that. I have 10 days from the entry of the written order, 14 days, for the entry of the written order memorializing the court's recordings. It seems, although I don't have an answer on whether an intervening arraignment would affect the posture of a request for permissive appeal, I can tell the court this. If we're put to an arraignment before we seek leave to file for this appeal, we will stand mute and not participate in that, not wanting to waive or imperil our position on the request for this interlocutory appeal. So, the better practice may be to schedule the arraignment after the deadline, at least for filing a petition for leave to take permissive appeal. I think that's probably the wiser procedural course for the court to follow. Although counsel may well view it differently, that's the view at this table. The court. I did read the Webb case, and I understand that, as a result of that case, if you want to challenge the court's ruling, the lesson is pretty clear. You have to do it before the trial. I didn't see anything in there to suggest that holding an arraignment would prejudice the defendant in any way. But on the other hand, the court didn't really address the issue in this case. Mr. Kratz. Attorney Kratz. On the 9th of March, I did file the amended information already. That's why, when I was searching, I couldn't find it. It's already been filed. If the court can just recognize today that it's been filed, however the court wishes to address the responsive pleading, you can do that. Attorney Strang. I did not remember the date, but I do remember seeing the proposed, at that point, amended information. It was, I suppose, filed conditionally on the granted leave to file, which the court now has granted. And I certainly have a copy of the proposed amended information. The court. All right. Does the state have any objection to scheduling the arraignment shortly after the appeal deadline for the defense? Attorney Kratz. No, Judge. Once the court accepts or recognizes the filing of the information, an arraignment can be held any time. The court. Well, let's see. All right. How about 9 o'clock on, or Mr. Strang, is life easier for you? Or actually, we have Mr. Fallon traveling as well. Does 9:30 work out better for you? Attorney Strang. Well, I assume Mr. Fallon is in the same position. I have to be seated in my car 3 hours before the court starts, so I wouldn't be seated in my bed at 6 a.m., but I wouldn't be in my car. The court. What if we do it this way? How about 10 o'clock on May 30th? I will tell you here, for security purposes, the Sheriff's Department likes to have your hearing be the first thing done in the courtroom that day, so I have pressure on both sides here. Attorney Fallon. I don't know about Dean, but it doesn't matter to me. Whatever is convenient for the court and security purposes. If you want to hold this at 7 a.m., I will be here. Attorney Strang. Right. Attorney Kratz. If all we're doing is the arraignment, I suspect Mr. Fallon is not going to be here. It should be a 30-second hearing. Attorney Strang. I will be here any time the court sets it. I was being a little bit flippant. Yes, it's a 3-hour drive, but I will be here whenever the court sets it. Attorney Kratz. Is there any chance of doing it just before noon on the 4th of May? The reason I say that, co-defendant Mr. Dassey's motions before Judge Fox are scheduled. I have to be here that morning anyway. And if we could, if this is such a short hearing, if we could do it sometime later that morning on the 4th, that would sure help my schedule. Attorney Strang. Both Mr. Buting and I have a criminal law section board meeting for the state bar at 11 o'clock on the morning of May 4th. The court. Where is that held? Attorney Strang. That one is in Madison. Attorney Kratz. The 3rd is fine, Judge. That's fine. The court. All right. Let's say 10 o'clock on the 3rd then. All right. Is there anything else that either party wants to bring up on the record this morning? Attorney Kratz, not the state, Your Honor. The court, Mr. Strang? Attorney Strang, no. The court, all right, if not, we're adjourned. We're adjourned for this morning. Proceedings concluded.